Greetings and happy Halloween, everyone. Or at least when I'm recording this, it's Halloween Eve, tomorrow night being Halloween. And I thought, what better time to talk about an interim clause? My name is Daryl Cartwright. I'm an estate planning attorney based in Birmingham, Alabama, and wanted to give you a short video to talk about this peculiarly named provision that you sometimes hear about talked in terms of estate planning and wills. An interim clause is basically probably about what you would expect. It seeks to terrorize someone. It's also known as a no contest clause. And the idea behind an interim clause is basically to prevent a beneficiary named under the will from contesting the will. You basically are trying to, as the testator, keep someone from challenging your will or provisions of your will. Basically, it is a conditional devise that is given to devise under your will that says, look, you get what I'm going to leave to you under the will, but only if, on the condition, you don't challenge the will otherwise. Now, in some states, an interim clause or no contest clause is not enforceable if there's probable cause to challenge the will. And I will say that here in Alabama, uh, interim provisions are not favored under the law, and they are to be narrowly construed. And I'll give you an example for that in just a minute about a Supreme Court case that addressed a similar type of provision. Now, when would you use an interim provision? Is this what you would use if you wanted to disinherit someone? And the answer there is no. You would not use it in that event. And the reason is if you disinherit them, they have nothing to lose by challenging the will. So what? An interim provision says that you lose what you leave to them under the will if they challenge the will. Hence, you've got to leave something to them in the first place. So by definition, if a beneficiary or someone is, well, they wouldn't be a beneficiary if they're not listed in the will, but if a potential devisee, maybe a family member that is being disinherited or someone else doesn't receive anything under the terms of the will, they cannot be terrorized, if you will, by the interim provision. It's not going to be effective for them at all to keep them from challenging it. Would you use it if you left somebody $1 under the terms of your will? Would that be an effective use? Well, that technically would meet the definition. It would meet the qualifications because the interim provision states that they lose what you leave to them under the terms of the will if they challenge it. But $1, really? Is that going to dissuade anyone or deter anyone from challenging the will? And the answer there is clearly no, it would not. So that would not be the kind of time that you'd want to use it. Instead, when you'd want to use an interim provision is simply this. You want to leave a beneficiary enough, a substantial amount, something that would cause them to have to think, wait a minute, I've got something at risk here, something real at risk here. And each one of these situations is different. If you're dealing with a $1 million estate and there are two children involved and one of them receives $995,000 and the other $5,000, probably the $5,000 won't be substantial enough if they believe they have some sort of reasonable grounds to challenge the will to deter them from doing it. So what? They'll roll the dice for $5,000 thinking that maybe they're entitled to half of the estate. But if you left that particular person $100,000 compared to $900,000 for the other child, would that be enough to make them think about this very carefully. And my thoughts are that it generally would. Obviously, it would depend upon the circumstances. Each individual situation is different. But in my mind, that generally would start the process. Wait a minute. You mean if I contest this will, and I'm not sure I really have any grounds for doing it anyway, person's entitled to leave the property to whomever they wish. And you're telling me if I challenge this, I might lose that $100,000 devise? Maybe I better not challenge the will. That's what the interim provision is designed to do. That's what it's for. Now, a minute ago, I said that Alabama interim provisions are narrowly construed and they're disfavored under the law, and they are. And a good example of that is a Supreme Court case in 2007 in which the decedent's will had a provision. And the provision said that a certain bequest was to be divided among several beneficiaries according to however they agree. And if they couldn't agree, then it would be determined by the executor. The decedent's will further stated that any further dispute by the beneficiaries would result in them being disqualified from that distribution. Well, two of the beneficiaries, after it was all said and done, decided to bring a will contest. They were unhappy. They decided to bring a will contest. And the Supreme Court held that their will contest did not violate that particular provision. The Supreme Court said that the challenge of the disposition itself was not the same as distribution, and hence it would not count as a disqualifying challenge in that situation. Now, the moral of the story here is that they are narrowly construed. If you're going to have an interim provision, it needs to be very specifically drafted to address very specific situations so that in the event a challenge did occur, it would clearly fall within the scope of the interim provision and the kind of things it was designed to protect. Otherwise, you probably will not have that act in an effective manner, and our courts will not likely uphold it. As I said, it's generally not favored, but it can be an effective deterrent. I know that I have used this numerous times in my practice, as have other attorneys throughout the state, and we're doing it for a reason, and the reason is to deter in that kind of situation. So if you have a particular situation where you think that might be of value to you, be sure and talk to your attorney about it, and make sure that you discuss very specifically the concerns and what you want to address, and have that tailor-made to fit that situation. I hope that helps. See you next time.